Good morning, Bougie Gang. Good morning, good morning, good morning. How's everybody doing today? It's Tuesday. I'm like, what's today? Okay, it's Tuesday. Good morning. It is October 22nd, if you can believe it. This year, 2024, like, I don't know, it's flying. Okay, it's flying by. So you better enjoy it while you can because it's going to be over before we know it. Good morning, good morning, good morning, good morning. I'm gonna have to go through the list on my YouTube side because it started off with Jay Blake, and I know that was probably right when I went live. So, good morning to Mimi. Good morning to the Funeral Duchess. Good morning, Peach Tea Sweetheart. Azure. Good morning, Bible Lady. Good morning, Denise Ernest. Good morning, Carla R. Just damn. Okay. I am Coco Kiyonce. Good morning. Good morning. Good morning. Good morning, India. Good morning. Good morning, Fussbox Girl. Good morning, Kina. Good morning. Let's see. Make beauty forever. Good morning, Azure for the 2 times. V the one. Good morning, Jay Blake. Blue Sapphire. Good morning, Jay Breezy. Rita. Tamaria L and Miss HLS. Hey, baby. Good morning. Good morning to all of my boo boos and my bebes. Good morning. Good morning, Simone. Simone. Hey, boo. Okay, guys, the prosecution is set to rest today. I want to talk about a couple of things. Number one, when Sarah said, "How do I get back George's wedding ring?" Soul Power, good morning. She was talking about one of those thirsty pick me rings that women buy for men who are not to be trusted because they think that having them walk around with a wedding band makes them not cheat. And he's just a boyfriend. And if he's a husband with a wedding band cheating, that's even worse. But that's not the topic today because George was a boyfriend and she gave this guy a ring. Harriet's laughing. Exactly. Stupid, right? Like, girl, and you're on trial for murder. It's the irony of all of the things, second degree, right? Good morning. Good morning. Good morning. Good morning. Good morning. That's one thing. Number two, if you saw the short that I put up, girl, it totally went over my head, but I might have been on mom pickup at that moment. Did y'all see Sarah get busted out for lying about George going to buy the wine at Publix? So that was the reason we had the Publix manager there. Obviously, we knew the wine was purchased from Publix, but we didn't know it was a whole lie that Sarah said George went to get the wine, but specifically they went to get the wine. Then there was another occasion when George went and got wine by himself. So she got busted out for another lie. Okay. Then so that's number two, the lie, the Publix lie. Number three, again, we were having a great day, but the witnesses, the next door neighbors stated, yeah, it wasn't a good day. They were fighting around 7, 8 o'clock. And around 11 o'clock, we heard loud thunderclaps coming from on high and a big thump that sounds like probably the suitcase rolling down the stairs, right? Um, then, so that's number three. Number four was I guess her sitting there in the interrogation with her list and telling them like there's a bat in the suitcase and some items and when can I get the ring back? I was like, girl, you are ballsy, okay? Um was there anything else that I missed? I feel like those were some of the highlights for me yesterday. Just to go over yesterday, I need to update my list. But we had Dr. Sarah Zajdowicz, Meredith McCaskill. So Dr. Sarah was the forensic pathologist that performed the autopsy. Meredith McCaskill was from FDLE. Florida Department of Law Enforcement. She spoke on the reports and the DNA reporting. Wanella Walden is the one who scrubbed the phone for the data, extracted the data, and created the analytics and reporting regarding the iPhone in question. And then we had the now legendary Chelsey Koepsal with the very dry humor that's oh so appreciated. Because she's kind of funny with it a little bit. Chelsey Koepsal, let me add her to my list. I neglected to do that yesterday. She is now a cold case detective. But maybe they do rounds, you know what I mean? Like they may have, I don't know, they could potentially, I would imagine to be good at everything as a detective, they probably have you do like rotations, I would think. So fresh cases, cold cases, high profile cases, all of those things. So she was the lead detective on the case, and we saw the interrogation videos. The interrogation videos came to play yesterday, and it wasn't pretty. Sarah got caught in many lies. I'm sure we could probably come up with more lies that she told, but I feel like those were the highlights for me. I don't know about you guys. Let me check the feed and see if they're let me get my shit. Okay, girl, we are on it, because as soon as I clicked on it, it went to the medallion. You know, we don't want to miss the shackle shuffle. uh Y'all had really good feedback yesterday. You enjoyed the super duper extremely long live stream yesterday. And of course, because Bougie Gang loves a nice long live stream, I know this. If I don't know one thing, I know y'all love a long live stream. Okay, let me check law and crime. It's like as soon as I click into one of these lives, that's when it goes silly on me. Uh Law and crime, I don't know. Their feed is okay, here we go. I'm like, I was about to start talking some mess, but okay. Okay. Are they ready to go? Baby, law and crime is up. I don't know. Court TV must be in the bathroom or something. I don't know. All right. It doesn't seem like they're started yet, but let me get my headphones in. Give me just a second because I had to set this up. Okay. I'm sure he's going to be well. Oh, Sarah's not even there yet. That's important. Okay, let me see what you guys are saying real quick. It was intentional, girl. It wasn't not intentional. Are you talking about that statement? It was intentional and done with crazy and malicious intent. But there was a certain point, I'll find it in the over 9 hours of testimony or 9 hours of footage. Um when she said, when they were just about to arrest her, and she said it wasn't not intentional. It wasn't not. It wasn't not intentional. She said it just like that. And he said, "Oh, so it was intentional." And she's like, "No, it was not intentional." But Sarah is the type, because she's not, you know, look, this is not a judgment. This is just a fact. I don't know that she's very well educated. I feel like she's the type of person that thinks that if you throw a couple of extra words in there, that shows how smart you are. But a sign of your true intelligence is to be able to use your readily available vocabulary as efficiently as possible. say what you mean what you say with as few words as possible. Trying to word salad is not cute, and it doesn't make you look smarter. It actually looks like you're struggling. So I don't know what the hell. I don't know what the hell. Okay. Yeah, it wasn't not intentional. I have a hard time under like double negatives. It's like, okay, what? Um, okay, here we go, girl. Shackle shuffle. Okay, her regular handler. Somebody asked, why does she have the shackles around her waist? Because it's probably would be more inconvenient for her to have them around her feet. She probably has them being transported from the jail to the courthouse, but from probably the basement to the courtroom, it's looking like it's on some, we'll just have you around your waist. And if the sheriffs have explicit instructions to not let go of the lead or the chain or shackles, however you want to put it, then they're holding on to her. And there's only but so far you're going with a waist belt and someone who has explicit instructions to not let it go, right? Um Also, she's handcuffed. So there's only but so far she can go because the shackles are attached to the handcuffs. And I think there's also a lock because you see her kind of locking in the handcuffs, and then the last part she locks maybe into some sort of little lock. So there's two locks to manipulate. If she were to manage to get herself outside, someone would have to manage one lock and then unlock the handcuffs to get her unencumbered. And by then, I'm sure, you know what I'm saying? Like, girl, it would be a wrap at that point, right? So it's for the protection. I mean, this woman is on trial for second-degree murder, and she did not earn a bail, and she is not permitted to be free. And it's for all of us upstanding citizens to be safe when she is not in the confinement of the jail, because ma'am unfortunately has conducted herself in a way that has put her in the custody of the state of Florida. Okay. So we need to be safe from people like her who are not operating according to the rules. So that's why ma'am is shackled. I'm sure she would like everyone to believe that she's safe and she's all of these things, but no. Okay. Let's talk about two. So number 5, if we were to have a number 5, the text messages with Mo, her and Mo going back and forth on text messages was a little questionable. Um It's my impression that when you see Brian Boone on the phone analytics, it appears that her phone was maybe in Brian Boone's name, which is, girl, was it that bad? Brian had to furnish you with a phone? Um we already knew this, but Sarah was salty about George having to contribute to his kids and his ex-wife, or I don't know if she was an ex-wife or not, but to the kid's mom. But it was okay for her to be caked off by her ex-husband. So it's okay for you to have your husband pay for your rent, upkeep, and all of the things. Um, but George, it was a problem because George didn't have a job. And George not having a job, at that time, maybe a lot of people were like, it wasn't even maybe, a lot of people were laying off and things like that. So we get it. You know what I mean? And RIP to George. He did the best he could, I would imagine, with what he had. He was dealing with Sarah. So
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Ma'am, good morning. Can you state your full name and date of birth for the record for us?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a black blazer and a dark blue blouse. She is in custody. However, she is not in any restraints, so we will continue to stand while the jury panel enters and exits. My understanding is that our panel is here this morning. State, do we have any housekeeping matters we need to address before we bring back in our panel?
Yes, sir. 3 discovery issues, and then I filed a motion late last night requesting an in-camera inquiry into a potential conflict of interest. I copied your JA.
I did review the motion.
Okay. The 3 discovery issues are these. One, on October 5th or October 4th, I believe the defense was provided with the body-worn camera 911 calls from the prior incidents, and there was a request made to tell us what, if anything, should be redacted from their point of view so that we could either reach an agreement or use the court's resources to decide any conflicts in those issues. Yesterday morning was the first actual response I got from the defense team, and it was incomplete. It was about 3 of the 5 incidents. I do agree with 2 of the redactions, and we're getting those taken care of. But obviously, just like connecting to the court screen, it takes time, and I'm not the person that's going to be doing it. Somebody else in the office has to do it. The 3rd incident, I think we're still not on the same page as to what the state's planning on introduce. So I resent the email with the screenshots of what files the state plans on introducing to the defense team again this morning. I have not heard anything yet from the defense team about the 4th and 5th incident. I was told that Attorney Beck was going to handle it. It is now Tuesday, day 7 of trial, and he has not handled it. Second discovery issue is Friday, I was given a hard copy of the 119 pages of the second copy of the Winter Park Advent Health records.
10/18, October 18th. That would have been the preceding Friday.
I was given the hard copy after court at about 5:30, 5:45. I emailed the PDF of those records back to the defense as they requested. I put Bates numbers on them. I understand from court what pages they indicated that they want to use and what pages the court indicated should be included at the state's request, pages 26 and 48 out of the 111. I would just appreciate if I could get a copy of the intended exhibit as it shall be introduced to the court so I can confirm those things ahead of time and not in court. And then the third thing is, I believe we had a discussion about the plethora of pages regarding the victims' hospital records, and that there was some sort of discussion we had that they were to narrow it down. And I have not been given any narrowed down version of that so that we can confirm we're on the same page or use the court's time if there's a conflict. Thank you.
Okay. Responses to the first discovery issue regarding body-worn camera and 911 calls is to the, my understanding, 5 prior incidents. Defense.
Judge, I can speak to 3 of them. There were 3 of them that I reviewed, and I believe I reviewed them on Sunday. I had made the decision for what I thought needed to be redacted. I think the first 2, if I remember correctly, I said that was fine. We didn't even have any redactions to it. I think it's one that I said redactions to, and I think the state agrees with that. The specific one that I didn't quite know, and I think that has to do with a body cam where it comes to, and I believe it's Mr. Torres's mother. I can't quite be for sure, but she's been asking questions and all, and I think it's about, if I can recall correctly, about Mr. Torres's whereabouts at that time. I didn't know the relevance of that at that time, but that was the only part of that to let the state know. I just don't really know the relevance. It could come in at a different point and become relevant, but as to the other two, I think we were on page with. I had been out to the jail that day, it was late. Then I asked Mr. Beck to do the other two redactions, but I hadn't had the opportunity to talk to him about that since, so that's where we are there.
So is the third incident that the state has identified for which there's seemingly no responses to redaction, is that the body worn camera purportedly between law enforcement and Mr. Torres's mother?
That's what I believe it to be.
Mr. J?
We're just
Bless
not,
you.
we're just not on the same page. On that third incident, which I believe was June 15th of 2019, the state only indicated to them that we were intending to introduce one video file. It is not of the victim's mother. It is of them at Sarah Boone's house. And the objection to the files that they were objecting to, which we don't seek to introduce, just said ID. And I don't know that as a legally recognized objection. So I'm confused. I'm not sure. I'm just trying to make sure we're all on the same page. We understand which file the state wants to use regarding that third incident, because he's describing files the state does not intend to use. The first couple of incidents, we agree. There's a 911 call that seemingly cuts off into an OPD call at 3 minutes and 51 seconds. We're cutting that to the end. The second one, Ms. Boone at like 3 minutes and 43 seconds indicates that she had been arrested prior. So we cut that out there. We're going to cut that out there. That cat's out of the bag. So what we're looking for now is just making sure we're all on the same page about the third incident. I sent screenshots. There's a tool called Snipping Tool in Windows. I literally create a rectangle around the files that I'm intending to use, their file size, and the folder that includes the OCSO agency case number incident, so we could be as crystal clear as possible. And I'm still getting objections about things we don't want to introduce on that incident, and I've gotten no response with the fourth and fifth incidents.
All right, addressing the third incident is the specific portions of the June 15, 2019 incident, seemingly the body worn camera that you're making reference to, Mr. Henderson, the state has no intention of utilizing.
Yes, sir. And just it's a lot, so if I could have one more
Sure.
to isolate which incident it is. That's not the one. My understanding is the state is talking about the third incident. That would be June 18th.
Here's the problem. I sent these pictures over with the OCSO case number, and then I get a response based on incident dates. So we have to kind of cross-reference. So we can just make the record entirely clear. OCSO incident 18-067501. There was no 911 calls and apparently no objection. So they have no redactions requested for that 2018 case. Then the next response was 6/15/2019 case. And that, for the record, is OCSO 19-054917. Their request on that one was the 911 call that we just discussed, indicating that at 3:51, well, I had to find it, 3:51, it turns into another case, and to redact that to the end. We agreed. Video 3 in that file, again, no file name, indicates that 940 to 943, there's a redact request with previous arrest. The state agrees to that. We heard her quickly say that at 943, and we will get that taken care of. Then their next response was 6/18/2019 case, which I had to cross-reference back to show that it is OCSO 19-055572. And in that particular case, what I sent them was a screenshot that includes the OCSO case number 19-055572, and it indicates there is an intent by the state to introduce 2 911 calls and 1 video file labeled axon_flex_2_2019-06-18_1330. My response that I received from them was video 3 in file, 2 minutes 7 seconds to 2 minutes 18 seconds paren ID, and then video 4 in file, 2 minutes and 4 seconds to 2 minutes and 16 seconds paren ID. So my confusion lies in I did not indicate 3 or 4 files, it was just 1 file. And then again, with the other 2.
I don't want to address 4 and 5 yet.
Okay.
It's my understanding there's no response. We'll address that momentarily. Responses to the clarification as to what it is the state seeks for incident 3.
No redaction.
Okay, all right. With regard to incidents 4 and 5, Mr. J, could you place on the record what it is specifically as to those incidents the state may be seeking to introduce?
Yes, sir. So what we're calling incident number 4 should be OCSO 19-078009, August 28th, 2019. We indicated the desire to use axon_flex_video_2019-08-28-2024. And then at their request, they had desired to get photos of Ms. Boone's injuries from that case. There is a 19-page PDF file, which has pictures taken by law enforcement of her injuries. I don't see anything else in there. 1 picture of Mr. Torres, a couple pictures of Mr. Torres, but nothing that the state was objecting to. So that was at their request that they wanted photographs in. So that is incident 4, which is labeled OCSO 19-078009.
With regard to seemingly the body-worn camera that the state seeks to enter into evidence from August 28, 2019, what say the defense?
John, I don't know about the state's position on this. There's a portion of this video at the very end is very personal to an investigating officer that they may want to redact. We're not asking anything to redact.
Is the state seeking any redactions?
I'm just clarifying what their redaction requests are in that particular file.
Okay.
If they don't have any, then
So are there any redaction requests with regard to that particular file? Okay. I'm just keeping notes. Give me a moment, y'all. As to the 5th incident, Mr. J.
No redaction request, Your Honor. I do want to point out that we were apparently advised yesterday that the state was only going to use the 3rd video possibly. And so we haven't really spent a whole lot of time worrying about it since then.
Let me clarify as to what the 5th incident is, just so that we're all on the same playing field.
Okay.
Judge, the 5th incident is OCSO 19-079759, and that was on September 4th of 2019. Within that screenshot that I sent to them, Friday and then resent it this morning, was photographs of the defendant taken at that time at their request. Shows a cut in her ear. It's 3 photographs. Then there is also one body-worn camera labeled 1924755. Oh, strike that. 192473549_GEN_INV, and then the 911 call from that incident.
Any redactions sought by the defense with regard to that specific body-worn camera or 911 call?
Well, we're not necessarily seeking redaction, Your Honor. However, there are 2 separate videos. One seems to focus on Jorge Torres, one seems to focus on Ms. Boone, and there is clearly some redundancy. They're both body cams. One went upstairs where Mr. Torres was found hiding in a shower for bath. And so some of that's redundant, but there are actually 2 separate videos pursuant to the 5th.
Mr. J, are there 1 or 2 videos that the state's seeking?
There's one, the one that I listed in the file, not important for her.
Okay. Do you know if that's a... Bruce, can you find out what counsel's here for? Is that the video from the perspective of, as identified by Mr. Beck, one more geared towards Ms. Boone or one more geared towards Mr. Torres?
My interpretation of both of them is there's interactions with Ms. Boone, and then there's interactions with Mr. Torres upstairs after he's located.
Mr. Beck, the specific file number was identified. So just to confirm, no redactions? Okay, all right. So just as a recap, with regard to the first incident, the 911 call, the parties have agreed to redactions at the timestamp of 351 towards the end. With regard to the second incident, body-worn camera, a redaction from timestamp 940 to 943 has been agreed to. With regard to the June 15, 2019 incident, there are 2 911 calls and 1 body-worn camera sought by the state, to which the defense has no redactions. The August 28, 2019 incident, for which there is no redactions to the body-worn camera, but there is a 19-page PDF with photos that the defense intends to be included with that submittal, to which the state has no objection. As to the 5th event, 3 photos of the defendant, body-worn camera, and a 911 call for which there are no redactions. Does that clarify everything for the state?
Thank you.
Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, Your Honor.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense, are you in a position to provide, I believe we discussed it either Friday or I think it was last week, we discussed it as to how it was culled down. Yes, because we had the Richardson hearing on Friday, how that list was culled down and the additional pages that the state was seeking. And then if they were able to find, I believe it was page 68, we would readdress that. Have you provided that finalized exhibit to the defense as to those specific Winter Park health records from the 119 pages that the defense may be seeking to enter into evidence?
I believe they've received everything from us, Your Honor. We identified those documents that were not specifically addressed by the defense, that the state wanted essentially out of rule of completeness. I believe we're.
But my understanding from Mr. J was that they were looking for the tangible copy of what it is that you were actually looking to move in, those 12, 14, 15 pages. Okay, if you could provide that to them by noon, I would appreciate it.
I'm not sure if it's, that's what we're saying.
But if it's going to be moved into evidence, we have is it going to be moved in paper form, or is it going to be moved in digital by virtue of a CD?
We can get it, Judge. We'll work on it.
Okay, perfect. Just get it to the state. It doesn't have to be intangible. Just get them what it is that if it's an electronic format, that's fine. Just the state should be entitled to know what it is that y'all are intending to move out of those pages, just to confirm it. Lastly, with regard to hospital records of the victim, I know there were conversations and discussions about that list being narrowed down. The state has advised that details as to those narrowed down records has not yet been provided. What say the defense?
The hospital medical records for the victim, George Torres.
That's my understanding.
We need to do that, Judge. We've got to do that.
Okay. My understanding is that the experts are potentially teed up to testify tomorrow. I don't recall if those records are a basis of the experts' opinions.
The second expert is not likely to testify until Thursday. She's testifying in Bay County tomorrow. I will be here Thursday, and I spoke with Dr. Brandon last night. He will be present tomorrow morning as soon as he gets here from Coral Gables.
Did either doctors Brannon or Harper rely on those medical records?
Dr. Harper did. It's in her deposition that was taken a couple of weeks ago. I think the question was posed.
Ms. Perez, good morning. If you're here for pretrial, 19 Alpha, Judge Myers is covering.
I went up there.
Okay, thank you. You may continue.
Dr. Julie Harper, I know she considered the records of George Torres, and we took Dr. Harper's deposition, I believe, a couple of weeks ago. She was asked by the state about everything that she relied upon, and she did indicate that. Are we going to use or attempt to introduce those records? We'll pare it down if we are.
Okay, you've got till 5 p.m. today to advise the state as to what of those culled down records you're going to be utilizing. So they have the opportunity to review those in advance of Dr. Harper testifying.
And I apologize to Madam Court Reporter for speaking on top of each other. Dr. Brandon is testifying as a subject matter expert who does not have specific familiarity with this case. And so there are no medical records or any other records that he has relied upon other than his knowledge and expertise.
Okay, all right. State, any other issues we need to address with regard to the discovery issues that you brought to the court's attention this morning?
No, sir.
Okay, all right. Moving now to the motion. I have reviewed that motion.
Judge, we were not aware of the motion until he made mention of it, so we need some time for the lawyers to review it, for us to discuss it, and to see whether or not it has merit or not.
Okay. It was e-filed last night, looks like 9:37, and then sent courtesy copy to myself through Ms. Barrios and you, Ms. Rowans, at 9:38 last night. I'll give the opportunity to review that. We can address it after the lunch hour. And that'll give the court the opportunity to do any research during the lunch hour on it as well. All right. Anything else, Mr. J?
I looked at it briefly. I'm not for sure exactly what the allegation is. I don't know if we need to talk about that. So excuse me?
I'm not.
Can we approach the bench?
Sure. Come on up, yo.
Okay, so that was a good little meeting there. They had quite a bit of business to handle before the jury came in. So I looked to see where the motion was. I don't see the motion. Let me refresh my screen. But they said that it was courtesy copied, but it's not on the portal yet. Maybe I'm wrong. Anyone else see it, let me know, but I don't see anything. I would imagine Madam Court Reporter's very busy right now since they are actively in trial and has to, she's got a lot of paperwork she's being given. And then so some of the housekeeping items or the tracking in the system probably is falling by the wayside for her to get caught back up at some point. Anyway, but they said it was posted last night. I don't see it, but it, that doesn't mean anything. Anywho, lots of business. Sounds like they're going to bring in that body cam footage from when Sarah, I don't know why they would bring this up, but Sarah was charged with 3rd-degree hand problems. Okay. Strangler Bay. Sarah was on some Strangler Bay type stuff, if you guys know what I'm talking about. And she was charged with 3rd degree, but George and Sarah did not cooperate and did not pursue those charges. So I think we talked about that about a week or so ago. We didn't go all the way in depth, but we did discuss that matter. And basically, another one of their arguments in 2018, that's the body cam footage where the officer tells them that these type of situations can end in murder or death, and to kind of be careful. And, you know, this is for your own protection when they were separating them that night. And, you know, I mean, these officers see a lot and they know the prediction, you know, I mean, they can kind of safely predict like what's going to happen. I see there's a birthday in the house. Happy birthday. Is today the last day of Libra season? Are we officially in Scorpio? Let's see. Libras, I hope you got into it accordingly. Libra season. Okay. Tomorrow, one more day, one last hurrah. Libra is the 7th sign of the zodiac, and the sun passes through it from about September 22nd to October 23rd. Libras are said to be peacemakers and good compromisers who are adaptable and value harmony. The symbol for Libra are the scales, which represent the need for balance in a person's life. Happy birthday to all of the Libra family. Enjoy Libra season because Scorpio is coming through.
All right, thank you
To
all very
handle that
much. With
birthday
regard to
business.
that motion, we're going to table that for now and address it potentially this afternoon. State is advised they're ready to proceed. Mr. J shook his head yes. Defense, you ready to proceed? Mr. Owens, you ready to
Happy
proceed?
birthday, Siobhan.
Thank you. All right. Ms. Boone, are you still satisfied with your lawyer's representation of you in this matter?
Okay,
Are you
DMV.
still on board with the strategy that
Pre-happy
they
birthday.
employed in the use of your defense?
Yes.
All right, let's go ahead and stand and bring in our panel.
Let's go ahead and bring in the panel. Hopefully they all had their coffee, bathroom breaks, everything. So guys, just to let heads up, Chelsey Koepsal is going to be finishing up and the prosecution will rest. They said they're going to take a little bit of a break, a little morning break. And I mean, this could be quick. Now, why is he laughing? Look, this guy Beck right here. Do you see you saw his teeth? I don't know why he's laughing, but he's odd. Anyway, you won't be laughing when they get that verdict through. I bet you that's when you won't be laughing. But anywho, it looked like he pulled his phone out and he turned it off.
Jury entering.
Why they would want to use that body cam from 2018, I guess to try to make George look a certain way. At the end of the day, George is deceased, and it was by Sarah's callousness and cold-heartedness that occurred. Okay, whether he willingly got in the case or not, she
State,
made
you
a
recognize our
decision to
jury.
not let
Yes,
him
Your Honor.
out.
Defense, do you
So
recognize our
that's what I
jury?
stand
All
on.
right, everyone would be seated. Thank you.
Okay, y'all.
Members of our jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. All right, State, if you could please recall Detective Koepsal.
State would call Detective Koepsal.
I don't know if she can still accept it, but I'm sure that's not going to happen. She's not. You can't just like, I'm going to just say it like this. At this point, the deal's probably off the table. You can't just come up here and be like, "Uh-oh, I'm getting ready to get 23 years. Let me take the 15." I think it's probably a wrap once the trial starts.
Ma'am, good morning again. Could you state and spell your name for the record?
Yes. My name is Chelsey Koepsal, Chelsey, Koepsel.
Mr. Castore, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene. Is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving. Is that correct?
Yes.
Were you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who is your partner now?
Detective Scott Lowen.
And throughout the whole time, you and Detective Lowen worked on this case together. Is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including like deputy sheriffs, like in uniform?
Yes, ma'am.
Yes. Oh, approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
All right, so that had already been done by the time that you arrived. Is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your, or what you're trying to accomplish in the investigation is basically get a basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses. Is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone. Is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it. Is that correct?
Yes, we have.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement. Is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it. Is that correct?
Yes.
Okay. All right. So, and out there, that's part of talking to witnesses or potential witnesses. Okay. Also, it's your job too to identify potential physical evidence in a case.
Yes, it is.
All right. And in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right. And was Miss Melissa Rothengarten, is that how it's pronounced? Pronounce it for me.
Rough Garden.
Rothengarten. Okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea of how that process takes place, please.
So yes, when I initially arrived on scene, I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, And then when my CSIs arrived, they would go in, take pictures, and then I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted, to kind of follow up with like things that I was told that would help us like identify things from the scene. And so, I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct, or pictures, or actually collect and take away. Is that correct?
Yes, so it's accurate.
All right. In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically, but that is what I recall.
Correct, and I understand, and that's fair. Okay, so potentially you collect these items because you believe they're evidence for the case potentially, is that correct?
Yes.
And some of these items you actually collect with the potential that you might need to have them examined in greater detail, is that correct?
Yes.
Okay. An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that. Is that correct?
Yes.
And also the stuff that you're learning outside of these items also helps you in making that determination. Isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
All right. out of the items that were collected at the house or the apartment, at those items, was anything to your knowledge sent off for further examination?
I believe so, but if it was, they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time, there were some fingernail clippings or fingernail swabs taken from Miss Sarah Boone? Is that correct?
Yes.
And in fact, that was done on her interview date on would have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video.
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of George Torres. Or are you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay. Yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it to the crime scene investigator, and she would author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
Are you aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question about it, okay? But basically, you're aware that it was done, the procedure was done.
Yes.
The analysis was done. Okay. Now, ma'am, so you're through the first day. Then we get to the second day, which would have been, I believe, the 25th of February. Is that correct?
Yes.
And on the 25th of February was Mr. Torres's autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
And did you communicate with the medical examiner at that time?
Yes, I did.
During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, Did you view Mr. Torres's body?
Yes, I did.
Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
Okay, so after the autopsy, you had additional information, is that correct?
Yes, I did.
Now, there was an interview, well, I don't know if it was an interview. There was a meeting set up for Sarah Boone, is that correct?
Yes,
On the 25th? Is
Yeah.
that correct?
yes.
Can you tell me how that meeting was arranged or how that meeting was set up?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification. And I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy. And then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving. We're going to make next of kin notification. She was very concerned about that. So I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone, is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone, is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry, did she give you permission to take the phone?
Yes.
Okay, is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time, you hadn't applied for any type of search warrant to get or search the phone, is that correct?
No, it was based off of consent.
Okay, so she had consented to you to, for you to have her phone, is
Yes,
that correct? She also provided you the code to get in the phone, is that correct?
yes,
So at this point in time, Ms. Boone is cooperating with you, isn't that correct?
yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded. And at the time, I was willing to give back her phone before going through it. And then once we had gone through it and those videos were found, I felt like this was very different. And it changed my perspective on consent. And I decided at that time that it was best to write a search warrant. So consent couldn't be basically like I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed until, I didn't submit it until the next day. And then it was signed the next day on the 25th.
So basically what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received, is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could I knew I could get a search warrant to go through the phone based off there being evidence, like the 911 calls, and her explaining to me that they had spoken to family members.
Please silence your cell phones.
Since they had explained to me that they spoke with family members the night prior. So I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yes, she could have not consented and she could have not signed the paper consenting while we were on scene.
Okay. But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
Okay. So did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific, if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 20th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day, or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then, but she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her to set up this meeting with her. Is that correct?
It's one or the other.
One or the other?
Yes.
Okay. As it to it being one or the other, you did you prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes, it was a summary, yes.
All right. As far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to not to the end, but to the point where the report stops. And it seems like in your investigative report, you are very thorough about details. Is that correct?
I would say I'm a detailed person. Yes, thank you.
Okay. So being the detailed person you are, and absolutely doing your law enforcement training, they tell you, they train you that your report should be very much in detail. Is that correct?
Yes.
Okay. Because you might have to refer back to them at a later time. Is that one of the reasons? Is that correct?
Yes, and to prepare myself for depositions and trials.
Okay. And just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you down, and where did y'all meet?
The Orange County Sheriff's Office Central Operations.
to meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report.
Okay. Do you remember in having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good? You remember telling her that?
That never happened.
Okay. Ma'am. Judge, if I could have a moment.
Yes, sir, of course.
Ma'am, during this time frame, were you pregnant at this time, at that time?
Yes, I was.
Okay. All right. Well, anyway, Ms. Boone, there was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Ms. Boone showed up for that meeting.
She did.
25th.
Yes.
We saw it. Okay. Now, ma'am, I'd like to talk to you about some other investigation on witnesses, other witnesses that you took their testimony or statements, recorded statements at different times. Okay. Do you remember Abraham Marino?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Marino's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay. Ma'am, as to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
So the relevancy in the pregnancy question is we all know that Chelsey was pregnant at the time. And according to Sarah, she said that Chelsey told her she wasn't feeling well due to her pregnancy. Like, I'm having cramps or whatever. Sarah tried to make some sort of assertion that Chelsey mentioned something about like pregnancy aches and pains or not feeling well, and that she should come down to the station tomorrow to collect her phone. And just what Chelsey just said, she said that
Ma'am,
never
do you have an
happened.
independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Ma'am, are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Moats?
I believe so. It was either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
All right, I would again object. She hasn't indicated that she needs assistance with her memory.
Okay.
So what maybe some of you guys know or don't know. So Chelsey in the last couple of years
Objection
had a
sustained.
situation with some documentation on a police report, but it was accurate, it was valid. I wonder because Sarah Boone did write a letter, let's say 6 months ago, bringing up this particular investigation that had been done. Chelsey was at a scene. She recorded witness statements. She got a search warrant based off of the witness statements. One person she talked to, but she hadn't taken the official statement, but she'd spoken with them at, on the scene, right? When she wrote up the report, the way it was stated would give the impression that all of the official statements had been taken. That person's statement was taken afterwards, but she had been spoken to, and the information that was recorded was valid. There was a discrepancy in that was noted. It still stood. It was still okay. She was I wouldn't say sanctioned, but it was documented. And I don't have all of the details surrounding that, but that's the gist of it. And I feel like they're trying to tippy toe into her credibility of documentation. We shall see. But that doesn't have anything to do with this. But, look, have you ever been at a job and you make a mistake? I mean, it happens, right? It wasn't a mistake where she accused the wrong person or she gave false information. Maybe, like I said, she'd interviewed someone, but I guess it wasn't the official recorded statement. And maybe that's the procedure to get the search warrant. There was one thing I think that was like out of step, and it was called to question. Everything was reviewed. I read the whole entire report, but they said that everything was reviewed and she was okay, but there was maybe like a talking to obviously it was documented. It was something that came up in that other person's case. Okay. Maybe they have become aware of that, which I'm sure they have, because like I said, one of Sarah's many letters to the judge, she brought that up, trying to question Chelsey Koepsal. And I don't think it's going to stand up. So just to put that out there. She's grasping. She's reaching and grasping. to try to, they're just trying to put reasonable doubt out here, you know.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you. Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres, is that correct?
Yes.
And he's the one who told you about the loud noise, is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent. Do you know his last name?
I would butcher it.
Me too, but tag Lowen, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Now let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. Did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object this for relevance.
Approach.
I think they knew they were going to arrest her on the substance of the videos, but they also were waiting to hear her lies. Okay. I think also what Chelsey mentioned is that the series of lies and the conflicting stories, the ever changing add on, like even just now, we know more about the bat. So I think based on what they knew they were going to arrest her, but it was the inconsistent in the stories. It might have made the difference between a manslaughter and a second degree, because they came out the gate with second degree murder versus a involuntary manslaughter. So it probably also, the questioning probably also like gave them like, okay, where are we going with this? Are we going manslaughter? Are we going second degree? I think her overall demeanor, disposition. She said it wasn't her fault. That doesn't still mean that you're not going to be held to account. A lot of people do stupid stuff that's not their fault, and they're sitting in jail because they should have known better. Ignorance is not a defense. You know what I mean? Like, you were playing with someone's life, all of those things. So maybe that could have been the difference potentially, but we don't know. She knows, obviously, but based on what they
Objections overruled.
collected, yeah.
So ma'am, at that time, you did not tell Ms. Boone prior to coming down there that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Ms. Boone that she was going to be arrested?
We planned to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, not come. And then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her?
She was read her rights that said that she has a right to an attorney. And if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, like physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Ms. Boone shows up and you tell her that some things that we need to talk about. Is that correct?
It's specific verbiage. I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
I'm sure, don't worry, guys, the state will redirect and probably have her restate that she was Mirandized on the scene twice. She was Mirandized at least once on site, but at least I think twice in that recording. She could have been Mirandized 3 to 4 times. They went through this in pretrial, so it's fine. Don't worry, because I'm sure Mr. J is sitting there like, mother effer. Okay. So he'll straighten it all out. You see Mr. J or Mr. Cacciatore come through and play cleanup. So let Henderson try to confuse people. It'll be fine.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings. Is that correct?
Prior to, I'm sorry, one more time.
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings. Is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she's read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am, at that point in time, Ms. Boone wasn't under arrest. Is that correct?
Ms. Boone was not going to be free to leave once she was in my custody.
At that point in time, had you told Ms. Boone that she was not free to leave?
No, I did not.
At that point in time, had you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview.
No, I did not tell her before the interview.
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her Miranda warnings, and that's what I did. I do not have to tell her that she is under arrest at that time.
Was there a reason? Could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as it calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach.
I mean, they can't throw out Sarah's, everything, but I mean, are they trying to make Orange County Police look bad? I don't know. Are they just trying to make Chelsey look bad? Are they trying to, I think they're just trying to find a technicality to take, like, at the end of the day, we saw the video and we heard the erratic behavior and the story. We saw the lie of you saying that you didn't go buy wine when you went. Like, if you're going to lie about going to the store to buy wine, what are you covering up? You know what I mean? Like, you're lying about going to Publix. Why? It's weird. So I'm sure the jury is going to be able to see beyond all of this, like, technicality. Meanwhile, yeah, the defense is so not prepared. Anyway, let's see. She was detained. If you get pulled over, I mean, don't take it literal, but if you're pulled over, if a cop pulls you over, like you're speeding, right? And you have lights, you have to stop. If you don't stop, it gets really bad progressively, right? They get out the car, they talk to you. You don't have to say anything. You're not, but you don't have to say anything. And most people know that. They also don't have to read you your rights at that moment. But technically, if you are detained, it is a form of arrest, even without an official kind of, we're placing you under arrest, like we're taking you downtown. It's a stop, it's a question, and you don't have to answer the question, but you do have to stop. He was most definitely detained. She should have known better. I think she thought she was in the clear.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people such as Ms. Boone, let me specifically. In the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
May I confer, Judge?
Yes, sir.
Thank you, ma'am. I have no further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released? State.
Thank you, Jesus.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
State, any other witnesses, evidence, or testimony to be produced?
All right, at this time, the state would rest.
Okay. Members of the jury, it is 10:22 a.m. I have some matters with counsel that I need to address. So we're going to excuse you for.
So let me just say this. I think, and there was a lot of talk about this. If you hadn't been watching the pre-trials, there was conversation about this about a week or so ago about the Mirandas. And Henderson was trying, I mean, this was already, there were already motions regarding the Mirandas and the motion to suppress the videos due to the Mirandas. The videos were shown. They did the motion in limine. They did all of everything. And here comes Henderson wants to talk about Miranda again. I think the judge probably just admonished him and was like, look, we talked about this 2 weeks ago and let's not go there. Like, we've already determined that the Mirandas were done. Everything is buttoned up as far as that's concerned. There were no areas of concern regarding whether Sarah had been informed of her rights. And also on the flip side, Sarah's ability to open up her mouth and say, I'm done talking. Or I don't want to talk. Or my son is home alone. He's 9. I came to get my phone. Oh, I'm not getting my phone back. Okay, well, I'm going to go contact my lawyer, or let me go call my ex-husband that I fall back on all the time or whatever, right? Okay. All right. Okay. Now the dogs are being vocal. They were being so good. Okay. All right. Let's see what's next. Probably a little bit of a break, little coffee break.
For a short while. It's a great opportunity for us to take our morning break as well. Similar instruction that I've given
Little
to you over
coffee
the last
break.
couple of days. Please do not discuss this case amongst yourselves or anyone else. And do not conduct any independent.
Mr. Law student back there is very sharp. I'm digging the 3-piece suit. Guys who can carry off a 3-piece suit, it's a must. It looks so nice. It elevates the suit even more. I think I'm here for the sir. Okay. I like the 3-piece gray suit and the old school fat tie. Okay. Okay.
Research or investigation as the person, places, things, or charge involved in
Yes,
this case.
gonna be
We'll
nice
bring you
hot
back in as promptly
coffee.
as possible. Thank you.
Jury exiting.
Sir is giving, I'll be at the gym for about an hour after I finish at school this afternoon. Well, when she was in the interview, okay, let's just go back to that. She was in the interview and she says, someone needs to call Brian. You guys need to call Brian, because Lucas is waiting for me to come home. Call Brian. He's waiting for me. You need to notify Brian. So maybe I'm assuming he was home alone, because why would we need to call Brian? Brian knows you went. Like, to me, it was giving, I felt like she's that type. And, I don't know. Look, she's that type. Okay. I wouldn't put it past her. There's plenty of people out here that leave kids home alone. Let me tell you, I've got a kid that at 9, baby, if I even tried to go into the garage, sis would be right behind me, like, where you going? Where we going? Okay. Farrah is 13, and I'm not going to lie. Farrah has not ever been home alone. Never. Never. Never home alone. If I walked outside to a neighbor, okay. And I mean outside in front of the house. But as far as putting the car in reverse, baby, are you kidding me? Sis got her purse. She's ready to go. She doesn't stay home alone. Are you kidding me? A 9-year-old? I would never. But there are people out here who don't mind leaving some people leave sleeping babies to go run to the grocery store. Okay. If we actually knew how irresponsible some people really are, like what's going on out here, you guys would probably be mortified. But I mean, all you have to do is turn on the news and see. Okay, let's keep going because they're probably going to talk business during the coffee break. I think they pursued that argument for a minute because Sarah probably was being annoying.
Defense, any motions?
Judge, we do have some motions, but my client needs a comfort break.
Okay.
If we could do that, because it may be fairly lengthy.
Agreed. Let's go ahead and take that break. Court's going to be in recess for 10 minutes, and then we'll pick up any motion practice at that point in time. Court's going to be off the record. Thank you.
Okay, Sarah has to go make pee-pee. Sarah needs a comfort break. Sarah says, you're stupid. You don't know you're going to jail, sis? Oh my God. That rosacea is off the chain. I mean, I don't even know how they do it. I mean, she's going to have to be unshackled to be in the bathroom, I would imagine. Yes, sis, don't cross your T's and dot your I's. Handle you can't put above any one person that they're not going to try to find a loophole. Even Sarah Boone, you never know what people will do. Okay, the great seal of the awesome state of Florida. Hey, Florida.
Hey,
Okay,
everybody.
Jesse Weber. Come on now, Jesse. Okay, girl. Okay, Jesse Weber. I love Jesse Weber. I think he's so good. He's one of my favorites on Law and Crime. Okay, the guard will accompany her into the restroom. Absolutely, but I wonder, like, is it maybe they go into like a handicap stall or, one of the larger stalls and maybe she turns her back or whatever. I don't know. I would imagine somebody who's violent. I mean, Sarah hasn't demonstrated violence towards her guards, but that mouth, if you look at her incident management reports, I'm waiting for incident management report. Someone asked me for incident management reports and I'm waiting. They asked me what I wanted and I asked her to send me everything. I hope I get it soon. What's her last name? Zampignon. She asked me what I wanted on the inmate commissary report. Do you want her account history, which shows deposits, charges, commissary transactions, or do you want to know what exactly she bought on each commissary order? You already know what I sent back. Thank you for your reply. Can you send everything available? Girl, that was my answer. I just said, send it all. Send it all. We'll break it down. Okay. Send it all. We want to know we want to know everything. Send me everything. Okay. Here's the thing. Send me everything. Okay. And this is, sometimes you guys have no idea. So, some of this, inmate type work, girl. Oh, you know what? I forgot we have the luxury of time on our hands. Right now we are behind about 8 minutes. So guess what? Boom. I just gave us 8 minutes back and Jesse Weber is off the screen. And, but let me go. I'm going to give you guys a minute and I'll be back. I'm going to go and make some coffee real quick. How did I have it? Shoot. Maybe I had it like this. I'm not sure. Okay. We want to know what's on her Zooms, and Wham Whams. I'm working on it. Sometimes this stuff, like when you have, so I've been requesting stuff from a couple of places. I don't want to name names because people out there, you know what I mean? There's people, you know what I'm saying? But there's stuff I've been requesting for a minute that clearly I have established FOIA requests and it's not a problem. But when you're new, like for instance, I had to send a picture of my ID to Honolulu the other day. Okay. I had to send it and I'm still waiting to hear back. And then I had to mail them a check with a copy of my ID. Okay. Because I'm trying to get some BWC. Okay. And they wanted a check. Okay. And Bougie Gang was nice enough to contribute. You guys, 5, 10, 20 on it, all kinds of things. Girl, are we cool on Hawaii? I'm working on it. It's coming. I got the email identifying that there were 10 BWCs available. And basically she gave me the quote. So I got the money order and I dropped it in the mail yesterday afternoon. So it's flying off to Honolulu now. So I don't know if they're going to email it or what. I plan to call today, like maybe around 2:00 because they're like 6 hours behind. I probably need to put myself something on my calendar for 4:00 to call because I feel like that would be a good time. That'll be 10:00 in the morning there. So yeah, girl, can I get the mugshot? Like, can y'all hurry up and just send the mugshot, please? I've been waiting. And the police report. It's like, hello, I need the police report, the mugshot, and the BWCs. Like, what's going on? But it was too soon after the event. I need to look and see if there is actually a case. But in cases like the folk that I'm requesting, oftentimes they drop charges, things of that nature. So I do need to see if there's like an open if there is a case at the clerk of courts, because it's been a couple of weeks now. So even though in some places, Fulton County, it's up and running 2 days later, but I don't know if I even went that deep with it to see if I could find anything at the court because I probably pivoted, but we'll see. We shall see what's going on. But yes. But yeah, it's a lot of when you're doing this type of, I don't want to say investigative YouTube, but I guess it's evolved to that. You have to, it's a lot of to-do lists because you ask for stuff and then it's like, oh yeah, I asked for that like a week ago. Where is it? Some places, I guess my point was when you've established or you have municipalities that are automated, it does come quicker. But yeah, you have a lot of to-do lists and just kind of having to go back, double check, recheck all the things. Because it gets quite labor intensive. And I can't even imagine on the scale of like phone calls from prison who they are I mean, I'm sure they're working on lots of different projects, right? And that stuff takes time. And then you have to follow up. Did we get it back? Are they asking, you know what I mean? Like, is it, you know, is it free? Do we have to send money? All those kind of things. So this is the first time I've had to send money before, but it's been nominal amounts, like $20, something like that. Now documents, sometimes you pay for those online. I've probably paid up to $50 for on, you know, through, because based on the amount of pages, okay. Sometimes you have to pay per page. So if you have you have a big document, a voluminous document, it's going to cost. So that type of stuff. But yeah, it's interesting. It's all very interesting. I feel like I've learned a lot in the last year and a half. And it's trial and error. Okay, come through, student. We have another student
We're back on the
who
record.
put her
2020
rollers in
CL
today.
2603, State of Florida versus Sarah Boone. Appearances for the state.
Yeah, sure, on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Kevin back on behalf of Sarah Boone.
Do we have any motions?
We need to go.
You may proceed.
Find that first voting, you know.
Yes, sir.
Yeah, at this time, the defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit. I've been paying close attention to the testimony in this case, and I want to point a couple things out. First of all, we know that the court has essentially assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize. I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry.
Because George is dead. That's not enough. It's not enough to support a second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go to the jury? Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove. And Pursuant to the jury instruction in this matter, depravity is equivocated, is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life. The state has presented testimony and argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And even if they were to establish negligence, that's not homicidal. We know that suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is prima facie case that in fact she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response.
Yes, thank you. Standard at this time is just a prima facie case. Whether any trier of fact in taking all the facts in the light most favorable to the state and the inferences drawn from them establish the elements of the crime. There are three elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Miss Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m. 45 seconds would be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you, I don't care, laughing is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events. And therefore, we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement, both on the 24th and 25th, that I have no idea what happened. I just went to sleep, everything was good. And then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
Oh, thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes,
Ms. Boone, I have a couple of questions to go over with you.
Judge, if I may.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last, call whatever witnesses, put on the photographs, and then the client would be the last person to testify. Because of the nature of this charge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, for the court to then consider whether or not we established enough evidence for self-defense instruction. So she's gonna have to be going first as the witness. I'm gonna need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal. To just go through it again, because I know you've been asked to colloquy about all that. So I'm gonna need a few moments with, I don't know, 10 minutes maybe for the 3 lawyers, 4 lawyers to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity, but before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you.
Okay, guys, there's no audio because there is a 10-minute recess and your girl was feeding the dogs. Okay, I was feeding the dogs and I was making myself a very hot cup of coffee, which I had to stop doing because I'm like, I know the judge said they were taking a 10-minute break. Like, It's bathroom break time, guys. Okay, we're gonna talk. We will talk through the break, but just give me a second. I want to go get my coffee. My kettle is getting ready to go. Anyway, I think I've seen this a lot. Okay, give me just a second. Lammy's like, "What are you doing, Mom?" Okay. Yes, I call Lambo Lammy. Okay. Lammy. Lammy's so sweet. He's I've never had a boy dog. Anyway, okay. Let me see. I've seen this. You guys remember when we watched Susan Lawrence? They are gonna, when they go to put their case on, they're gonna ask for an acquittal. I mean, you guys who watch YSL, do they not ask for a mistrial every day? They're just doing their job. You know what I'm saying? Maybe, they're trying to, catch a technicality and or capitalize or take advantage of a technicality. So they're just doing their job. It's okay. That way they're not going to get ineffective assistance of counsel. You know what I mean? Like they have to do their job. And part of doing their job is just asking, right? So Lambo is our mascot. Yes, absolutely. You guys, thank you so much for supporting. I mean, don't, you know what I'm saying? Like you guys do it. I appreciate y'all so much. And contributing, it's very much appreciated. Certainly not required. You guys support this channel heavily, so it's my pleasure. And I'm here. I would look. You guys already know me. I I would be doing this anyway. That's how this whole thing started on Real Talk Bougie. I would be doing this anyway and for nothing, right? But I appreciate you guys supporting. You guys are awesome and thank you very much. But yeah, he's doing his job putting in the acquittal or trying to uh cast some reasonable doubt, even though the jury is not even in there at this time. He's, like I said, he's going through the motions of what he's supposed to do. I almost want to just give it one of these, okay, and one of these. And Sarah, girl, good. Sarah, if you weren't like this on that night, maybe you wouldn't be in the situation that you're in right now, okay? Okay, ma'am. Okay, but we're going back to being serious. I have been so good not using any memes all week. Oh my, you guys don't know how much restraint I've had to use trying to be serious chief moderator for the past couple of days where I'm just having to like, oh my God, I want to use my memes so bad. Anyway, so the defense is getting ready to start. Sarah is getting ready to get up on the stand. It very well might be a shit show. I heard that she might do narrative, and I don't know if narrative has ever been successful. If there are any lawyers in the house, please chime in and let me know if the narrative testimony has ever been successful. Because recently we saw the guy, was it Robert Tellis, Bob Tellis, who allegedly, there was a reporter who was doing some stories on a local politician by the name of Bob Tellis. Look it up. It was just in Las Vegas recently, right? And Sir didn't like his bad press. And we've heard this before. Didn't we see the couple from Facebook? Oh God, now I can't think of her name. Let me look at my RSS feed real quick. My RSS feed. Okay. Was it Gray? Anyway, let me stay on track. Yes, Grayson. The United States versus Grayson, and that is we'll talk about that also, but Bob Tellis did not like his negative press, and there was a reporter who was killed, and I think on his side or his backyard, and he did a narrative testimony, and it bombed. It absolutely failed miserably. And he, I believe, he was found guilty. I don't know if he got life in prison or not. I'm going to be honest. But it was not successful. He started rambling. He went off track. He was doing too much. He actually is a lawyer too, this guy, Bob Tellis. And it went miserably wrong. And by all accounts, to me, the footage that they had of the person who walked up to the man's house and took him out looked like him, and he walked like him and all the things. So not good. And narrative, it's been said that she is going to testify narrative, and if she does, it's going to be a mess. So we'll see. I think they want to have her do narrative because I don't think that they can cross examine Q&A if they do narrative, right? I want to say Ashley Grayson. Did anyone put that in the chat? Ashley Grayson is another person who was mad at some of the blogger coverage on TikTok, Facebook about her dealings on the app, and had a murder for hire plot against several people. And she was found guilty too. Her husband was acquitted. She was found guilty of murder for hire. And it's another case called United States versus Grayson. And then if you look up the state of Nevada versus Bob Tellis, baby, okay? He received 28 to life. And the man is not necessarily old, but he's got to be in his 40s to 50s. So 28 to life, baby, is not going to be pleasant. 28 is probably a wrap. Okay? Girl, Tellis was a narcissist if I ever seen one. He deserves everything. Yeah, I mean, it was really sad. The guy was at his house and basically unsuspecting, and here he comes in some weirdo outfit and did that nasty work, okay? Narrative, to my understanding, is also when the defense believes their client, so they can't participate in the lie. So there's something about it that could put their license in jeopardy. You know that there's some fugazatry happening, and due to that, you are opting out of the Q&A because they might. Yes, great point, Forever T. Thank you for mentioning that. Who is this guy coming through the gate? Who told you to come through? Okay, we'll see you for lunch. We'll meet you over at STK. We'll be over there. Okay. Owens is like, Sarah, are you sure you want to do this? Sarah, are you sure? See, look at everybody learning. Everyone's learning something new today. That's what the epitome, it's just, again, this commentary is for teaching, entertainment, all of the things. But I do love the fact that, majority, a lot of lay people in the midst. And I feel like this, sitting and watching these proceedings and hearing about life is educational, especially as it pertains to people who have entangled themselves into the court system, and law enforcement are questioning them about crimes. I mean, it's so interesting. He did get life, Bob Tellis. Ashley Grayson was pregnant, so I think they had a little mercy on her. She was in Tennessee. Um, I tried to get the transcripts of that, but I mean, who wants to read 1,000 pages of transcripts anyway? But it was, I don't believe it was televised. I can't believe it. But she was basically, there's a lady, you guys might know who she is. She's on Facebook. She's on Facebook, YouTube, TikTok, everything. Her name is Drika Harwell. She's one of these like success coaches, and she's quite successful, popular. She's like a Stormy Wellington type, very motivational speaker, but she has a product that she sells. Ashley Grayson was accused and sued for copyright infringement. And basically, there were some TikTokers and Facebook bloggers or commentary channels like myself who were calling her out, providing receipts, all of the things. And not only did she have a hit for Drika Harwell, she had a hit for the blogger. She also had a hit out on a girl who she allegedly awarded a home to, their mother. The girl who she tried to bring into the mix on the murder for hire plot, and her former lover that she cheated on her husband with. A mess. And this story might sound familiar because Tasha K actually interviewed the lover who was here in Charlotte and got a call from the FBI and was like in shock, basically. I think at the time they were in Atlanta, maybe. He was in Charlotte. The field office here reached out to him, told him that there was a murder for hire plot that had his name on it, basically, that there was someone trying to kill him. And but there were several people. So Ashley Grayson, she basically reached out to one of her subscribers who she thought she had like a loyal to the soil, and was going to, and asked her basically like what, how much, like she reached out to her subscriber like she was a pookie. Okay. That person that you think you know who will do anything for some coin, right? And that person immediately contacted the FBI, thank goodness. And basically the murder for hire plot was revealed. And so this is you should look them up. Ashley Grayson. We'll talk about it. If you go back down into my playlist, I did a high level. I did like 2-3 videos on it, like before the Shirley Strawberry Nesto thing happened, like around the time of our girl Carly Russell. And I mean, Nesto it took my full attention, Ernest Williams, because it was a little hard to get the information from federal court. But yeah, it's been deposed and Ashley has been found guilty. Her husband was acquitted. And there is a Carly Russell update too. Carly has paid like a couple $100 of her $18,000 restitution. And the judge basically told her it's not good enough. And her next court date, they said they need to see some significant, and that she needs to pay at least $50 a month, which will give you a good idea how much she has not paid, when the court order now is to pay at least 50. So I don't know if she's not working, and I'm not sure if the court mandated that her parents could not help her. So, you know what I'm saying? Like, maybe they don't want to either. I wouldn't blame them. But anyway, we'll get caught up on everything, y'all. We got so much to talk about. But Sarah Boone. Just like 504 said, Sarah, would you go ahead and take your ass to jail? Would you just go ahead and go back? She had a hit on the girl. Yes. And it was a Sherelle, and then Olivia, the ex-boyfriend, Drika Harwell, and someone else. Drika Harwell, she did a whole video on, she's talked about it a couple times. It's a very interesting story, the Graysons. Just go all the way down to in my playlist, but I'll bubble it up as a throwback. But the reason why she wasn't in jail is because she was pregnant. And I think, as fate would have it, while she was out, girl, she done got pregnant again. Okay. Looks like sentencing. Yeah. They keep postponing it because she was pregnant during the trial. She had the baby and her behind got pregnant again, which I don't blame her because she could be going for some years. And I think she's trying to secure the bag. And what I mean by the bag, if you're not familiar with my other channel, Love, Lies, and Lace Front, she's trying to secure the testicle bag. Okay. She's trying to secure that bag. She is married, but I think she's girl pregnant again. Yes. Mm-hmm. That was what the word was when it was postponed back in July to August. And then now, since it's October, I'm wondering if that was actually true. And I think because I went on her Facebook and I think so. Let me double check since we're like talking about it again, but I do think she's pregnant a second time. It would make sense if you're going away for 8 years and you have one child, if you can give them a sibling and try to prolong everything, stretch it out, even though she is, she was found guilty on a murder for hire. I think she has a pretty generous bond, and she might even be on like an ankle monitor and things like that. She's not going anywhere. Her husband was acquitted. And but yeah, I'll get some recap on this. I'm clicking on my feed right now. Let's see. Sentencing hearing has been reset for Thursday, October 31st, courtroom 2, Memphis, before Judge Thomas Parker. The parties are instructed to notify the case manager immediately. They anticipate eventually hearing lasting over an hour. The parties are also instructed to have present any witnesses who they will need for this hearing. Supplemental probation filing amended. They're not going to give her probation. Ashley Grayson, documented, available, applicable parties only. I don't know, but they got a lot of stuff. At a certain point, there was stuff like under seal. I don't know. If you look at her case file, she must have had a good lawyer because a lot of stuff was placed under seal. She paid those coins, okay? And she's also out of jail, okay? With a federal case. Sentencing hearing has been set. Okay, so it was like July to August to September, now October 31st. I'll check her Facebook. I'll get back to you guys on it. But I'm looking at the court notes now. Oh, okay. Well, we missed that. I'm gonna have to get caught up on all these notes, and I will if you guys seem interested in this situation, because it had all to do with social media and somebody pissed at their coverage and thought it would be a good idea to try to hire folk off the internet, which that was a bad idea because nobody wants to go to prison. It's not cute at all. Okay. Court is back. Y'all get your snack because Sarah's getting ready to hit the box.
Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Kester on behalf of the state. William J. for the state.
Defense?
James Owens from the Boone.
Tony Henderson for Sarah Boone.
Kevin Zach on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters. And if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
And do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering an affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarification, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay. All right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of violence, or any of the ancillary things that come in self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about that.
Okay. Then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at that. And then the third thing is that the state had filed that motion for the in-camera hearing. I don't know. Maybe we need to hear that before she testifies.
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that George Torres committed on Sarah Boone, and there's a dispute about whether or not I have to establish an overt act that she responded to, that she considered an imminent threat, and that she took evidence or she took action to either block or physically restrain George Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open that I can go into that based on those statements by the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures. They were going to see videotapes of evidence that George Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George, but then she realized she would have to disclose some of the acts that had been committed on her by George Torres. And so she did talk about him coming at me, and we've had issues before. And the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video. And so I think I can talk about the prior bad acts before the event in question chronologically. And I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, as we're trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020, before we go into reputation evidence, prior instances of violence, or matters of house income evidence.
Any other further argument, Mr. Owens? I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence.
Any particular reason why it hasn't been done in the last 45 minutes?
Because
When I sent my jury out.
I've been meeting with my client about her rights to testify or not, and other related matters. So in terms of not giving her this evidence?
In terms of anything that the state just discussed.
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase, which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25.
Early lunch, it's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here. And then I believe tomorrow is Wednesday. We've got Dr. Brannon that's going to be here first thing Wednesday morning. And then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence other than seeing it here today. But I think I need to do that with her before she testifies.
Okay. Can the parties approach for a moment?
Okay, Judge Cranick is probably going to rip into. Okay, so I pulled up so apparently the person who's going to, how did I lose my tab that quick? Okay, hold on a second. Let me share. I've got it over to the side, so don't worry. This is the docket, guys. We got the docket pulled up. It's a little bit updated. Witness to appear via Zoom is going to be someone by the name of Pearl Walker. I wonder if that's her. Wait, that's not it. Hold on. That's not it. Okay, here we go. Come now, James Owens, counsel for defendant. Court to grant Zoom appearance by Pearl Walker. The above matter was scheduled for 2 to 3 week trial, October 14th. Defense witness Pearl Walker's 81. I wonder if that's her aunt or something. They said she has an aunt. She got some cousins. I don't know who Pearl Walker is. Ms. Walker has experienced the death of several loved ones in the past year, which has affected her health, as well as having mobility issues due to her advanced age and problems with her knees. The nature of the witness's testimony is important and necessary for the defendant to receive a fair trial. Defendant requests her witness, Pearl Walker, be allowed to appear via Zoom. She's from Aviado, Florida. I felt like they said she was out in the hallway yesterday. I don't know. Now they're talking about the second item. They mentioned something about the in-camera regarding about the state's request for in-camera hearing regarding financial arrangements between defendant. So they mentioned something today that there could be some sort of conflict of interest. I'm not sure. Let me read this real quick. I'm just clicking on it. It's just got posted. None of this was posted this morning. So it looks like they are currently updating the docket. Madam Court Clerk, Madam Secretary is handling that business. So let me read some of this and then we'll talk about it. But like I said, I'm over here on the docket. Sarah is over here at the table talking to the jury consultant. Look, to the state's ooh, the gallery is full. Look at that. I wonder if a lot of that's Judge Cranick's class of folk. This is, yeah, that means very interesting. Would be a missed opportunity for people who are local and interested, did not attend. This is definitely very much like a big deal. Anyone else who gets the foolish notion that it's a good idea to withhold help from a loved one who is in imminent danger and thinks it's a good idea to take out a phone, taunt them, and take your ass to bed, and then be surprised when you call 911 12 hours later. If anyone thinks that's a good idea, it's not. It's not. It's not. Okay. So yes, the state is annoyed by the fact that we were just on break for 30 minutes and they didn't utilize any of that time to handle business. Now, were they talking to Sarah about her getting on the bench? Yes, but there's 3 attorneys. Did they all need to be there? There is the jury consultant, I think, who's an attorney. There is Henderson's daughter, who is an attorney. Any of them could have reviewed the evidence potentially. Now it's like a 15-minute break becomes a 30-minute break, becomes a 1-hour break, right? And then now we're going to be butting into lunch, right? So it's like we've been taking lunch around 12:30 to 2, and looks like they have about an hour. So I don't know if that's enough or not. I think Judge Cranick, for some of you guys might think he's being too nice, but considering that she has some lawyers who seem to want to capitalize on every opportunity for a mistrial, for an acquittal, for reasonable doubt, which that's their job, right? He has to exercise extreme caution because many people are in appeal or try to get an overturn based on technicalities. So he's being very, very, very cautious. And I don't think overly cautious, but I think, again, everyone's doing their job to the fullest. The defense team is doing their best. But I think that he is husband. Oviedo. What is Oviedo? I'm not sure. And thank you, Muffin. Let's see. Okay, so yeah, that's it. That's all. I guess we're waiting. And let me see. Is there any other questions, Pearl? Girl, don't even waste your Zoom time. Okay. All right, let's see what's going on that document. Let me try to skim through it really quick, and if we have time. It's the state's request for in-camera hearing regarding financial arrangements between defendant and the defense team comes now state of Florida by and through the undersigned assistant state attorney. The states and alleges the following. Defendant is indigent, had several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving costs money from JAC for her indigency. Apparently only investigator Billy Lane is being paid through JAC money. The defendant has secured the services of 4 attorneys and a jury trial consultant, perhaps more people that the state is unaware of at this time. The defense team is expecting a tremendous amount of costs, having traveled from Milton, Florida to Orlando for a several-week trial. The team returned to Milton prior to the arrival of Hurricane Milton in Central Florida and then traveled back after it passed, incurring additional costs. The state is concerned about potential conflict of interest between the defendant and her team. Rules regulating the Florida Bar 4-1.8 D. The only way for the court to know if there is an actual conflict of interest rather than a potential conflict of interest is to review the financial agreements between the defendant and her team. If there is an actual conflict, the defendant can waive her right with clear, unequivocal, ambiguous language for a waiver to be valid, and the record must show that the defendant is aware of the conflict of interest and that the defendant realized that the conflict could affect the defense, and the defendant know of that right to obtain their counsel.
It is 11:35. Councils have matters that they need to address.
Let me just finish number 8. The state is requesting the court to conduct an in-camera examination of the financial agreement to assure that there is no actual conflict of interest. And if there is an actual conflict of interest, the defendant validly waives their actual conflict of interest. And that's it. So basically they want to know, is there any repay agreement? Is this completely pro bono? I guess they just want to know what is going on financially and get it on the record and be clear once and for all. Is there a repay agreement? Because James Owens did state on an interview with Court TV, Vinny Napolitan, I remember when he first came on, and he said, Sarah's going to owe me. Sarah's going to owe me. So I don't know. Okay. So valid question. And okay, let's hear what the judge had to say.
Address with Madam Clerk for the pre-marking of exhibits, along with the review of the suitcase and bat, which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
Yes, sir.
Same question, Mr. Owens.
No, sir.
All right, let's go ahead and stand by, bring it back in our panel.
Jury entering.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
I think you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
You guys didn't miss anything. They're going for an early lunch, and I think they're going to, I don't know if they're going to handle any additional business and let them examine the suitcase right now. If Madam Court Reporter has her gloves on. Oh, she has her gloves on. I see a little white glove. I see. Well, is it? No, that was the sleeve of the blouse.
State and the defense, if you could please review those items and please mark every defense exhibit
Look at
this
Beck.
time with Madam Clerk. And
Why does Beck have his bag on like he's getting ready to go get a sandwich? Sir, if you don't sit your ass down, you are not here for a Orlando food outing. You are here for business. Put your bag down.
I will see you all to commence promptly at 1 p.m. Court's in recess. Thank you.
Look at Beck. Look at Beck getting ready to go. Okay, I'll see you guys in a little bit. I'll be late. You already know I'll be here at 1:15. Beck's like, I'll be back in the building about 1:05, 1:10. I'm gonna go to the bathroom. I'll be in here about 1:15. Okay. Look at Mr. J. Mr. J is like, look, we had a concert to go to tonight. He might have some play. He's tired. Mr. J is done. Oh, don't put us on the medallion. Okay. Okay, students. Come through, students. Okay. Guys, we're on break till 1 o'clock. I did read, let's see, there's some more posted. Let me go back to the docket real quick, and then I'm gonna let y'all break. Okay. There's another document that was posted to the docket. Let me let y'all see real quick. A special, so they requested, this was on today. There's a special jury instruction regarding Florida criminal standard for jury instruction defendant statements. So basically, where is it? Right here. So this was just filed at 10:17. Mr. J is like, stop playing with me. State's request for special jury instruction. So just like the judge read the jury instruction for the fact that Sarah's going to testify, or he's going to read it to the jury. We've already heard it because he previewed it to Sarah, but he hasn't read it to the jury yet, right? So he's going to read that when we come back from lunch before she gets on the stand. This is coming as far as, let's read. Comes now, state of Florida, by and through the undersigned state, assistant state attorney, and states and alleges as follows. The defendant filed a motion to suppress statements, which was denied prior to the trial. A significant portion of the motion was devoted to whether or not the detectives told, asked her something to the effect of, with these rights in mind, do you still wish to speak to us? This is not required by law. However, it is proper for the jury to consider. This is not required by law. However, it is proper for the jury to consider the totality of the circumstances in deciding whether her statements were voluntary or not. Therefore, if the defendant raises this issue in front of the jury, the state is requesting an instruction to be added 3.9b defendant statement so that the jury understands that they are solely making a factual determination regarding voluntariness, not a legal one. Are you guys seeing this? Okay. Let me make it bigger in case those who want to read along. And the statement is, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether a defendant's statements were voluntarily made. Okay? They're not required to ask that. This is a correct statement of law and would be required to ensure that the jury is not confused by inferring that it is legally required when it is not. Okay? That's pretty much it. And then he's certifying and copying and giving and all of the things that was filed by Mr. J. Okay? So we just read the motion for the special jury instruction that was filed. So they'll probably talk about that when they get back from lunch. The in-camera regarding potential conflicts of interest. How are y'all getting paid? Because y'all doing way too much for free. So is this for free, or are you guys trying to do a book deal? Are you guys brokering? Are you guys figuring out some sort of payment on the back end? Like, what's happening here? The state wants to know. Okay. And the defense's motion for the witness to appear via Zoom. I don't know if they've ruled on that or not. I don't know. I think that's it. I think we're caught up on the docket. We are caught up on Earthing. And I feel like I want to shut this one down because the mega long live yesterday, it had to be shut down on Facebook. So let's shut this one down. And can y'all imagine Sarah getting into that suitcase as part of her defense? Baby, yes, I can. They're with the trickery and foolishness and shenanigans. So of course, why not? I mean, you never know. I mean, it's a pretty, where there are some people out here on charges who have ideas of grandeur that their cases of monumental importance, and it's not. This case has built up a particular following, and it's also, on some mom killed her boyfriend. It's on some trickery. It's a toxic romance. It's a trauma bond that was a kind of like a fait accompli, where you have a police officer tell them 6-8 months before that these things are dangerous. It could result in a death. It ends in murder sometimes. There was a whole foreshadowing of this event. And the irony is that everything came true, right? And Sarah has been in jail now for 4.5 years, and she has been very unpleasant to the world. She has, her Her lawyer situation is legendary. Her letters are legendary. Like this is something I'm sure, and we've heard it in the comments, that the state of Florida would like to put to bed. So I think Judge Kranick is crossing every T, dotting every I, just to make sure that this doesn't have to be revisited, right? Sarah is going up there to appeal to the well. You know what? I feel like Florida showed us what they were working with Susan Lawrence. And I feel like the sensibilities of the people of Orlando, I don't think so. I think, you know what? Even someone who may not be the best person still has the right to life, liberty, and the pursuit of happiness, right? Even a despicable person. And I'm not saying George Torres was by any means, but we all have a right to live our lives. And George Torres chose this woman. She chose this guy. They were happy, unhappy drunks. And at the end of the day, they can try to drag him for his life choices and decisions. But at the end of the day, she recorded him. She had an opportunity to save his life. She did not have to zip the suitcase. He got into the suitcase on his own free will, but she made it a joke. So let's just say you took it from a hide and seek to a death chamber. You're playing hide and go seek. There was nothing ever said that George zipped himself into a suitcase. It said that she zipped him into a suitcase. So to me, I don't think so. I'm sure they're going to try to appeal to whomever they think they can is going to be sympathetic, but I don't know. I feel like I was so encouraged by the Susan Lawrence case, and that the people in, was it Ocala, Florida, where she lived, I think it was Ocala, something like that, made the right decision. And she's actually getting sentenced soon. Her sentence is coming up. It's the lying. It's the mixed messaging. It's the, I hope Mr. J comes up with, which I'm sure he is, because he's our kind of prosecutor. It's like, okay, story number 1, story number 2. I hope that in the closing he highlights the nuances between her version of story. I think that would be very effective. I think the nuance from story to story, and also just the lies. Here's where the lies came in. Okay, there's the different iterations of what actually happened, which we really don't know what happened, but we know George Torres is dead. And here's the lies. Here's the inconsistent statements, and this is what we know. And I think if you just stick with that on face, you don't even have to go any deeper, because she can't even come back from any of that. There's no proof, but let's just say he did. Her statement is that she zipped him up. Did he ask you to zip him up? If she goes over there on some Q&A, I think Mr. J is going to ask her, oh, well, who told, like, you zipped him up? Why? Was it, you stated that you wanted to make him squirm? You wanted to teach him a lesson, make him squirm a little bit? It's not going to be good. That's why I think she's going to go with the narrative form. I don't know if she's going to go with Q&A. Mr. J or Mr. Cacciatore it's not going to be cute. Oh, thank you. I love these cases. Anyway, guys, let's take a break. I'm going to shut this down. I really wanted to do, okay, so to all my so anyone who follows here, I want to do a reaction to phone calls from prison last night. I was so tired last night. I did not get a chance to come back, but they dropped a video. I listened to most of it. I'm going to try to listen to the rest of it on this break. So I can be prepared, because I know you guys love my kind of immediate reaction versus more of my like, okay, I'm listening along with you because you guys already listened to it too. So let me get finished with my homework, which is listening to the rest of the call, and see if I have the energy at 5:30 to come back, and maybe I'm gonna take an opportunity to go ahead and start my dinner, so that I don't have to worry about trying to expedite things later. So let's do that, but also let's talk about this too really fast. It sounds like between today, tomorrow, they may have someone Thursday. It sounds like the defense might be shutting it down Thursday, maybe Monday. So the jury could have this, we could have a decision by the weekend, y'all. You just never know. So because if the jury feels kind of like, okay, this is a no-brainer, she's guilty, we could have something by Friday, you never know. But the defense is officially going to be starting this afternoon. And we're going to see how it goes. So get a nice little lunch. I'm going to take this one down. I'm going to put one up. I should have been typing while we were talking, but girl, give me a minute, and I'll have it up, and come on in. And let me see. If you guys want to hold for just a second, let me try and do it really quick, and then I'll do a redirect. My bad, y'all. Let's see. Should I use, oh, where's mine? Okay, hold on one second, guys. Give me just 1 second. I'm just gonna copy and paste this over real quick. Let's see. Yeah, because yesterday was like a mega long. That was mega long. Okay. But let's see. All right, I'll do the description box later. Oh, I have to have a description box for. Okay. All right. I will drop the link in the chat. So you all are cordially invited to join me after lunch at 1:00. I'm going to put a time to it also. Let me put one just so people aren't falling in like, oh, this is starting now. Schedule for 1:00. Y'all, we have a whole hour. Okay. Okay. 1 p.m. Okay. And let me get the. Okay, I'm going to drop a redirect, but let's see. Here you go. Here's the link. Let me set up a redirect now, so when this shuts down, you guys will go right into it. And anyone new here, welcome. I appreciate y'all coming through. Thank you for joining us for this first portion. I hope we see you back again. We're a fun bunch, okay? And that's it. That's all. Let us know. Drop any questions, and make sure to subscribe, set your notifications to all. And if you would please, if you enjoyed this first half, make sure to hit the thumbs up for me. It's a free way to support the channel, and it's very, very, very much appreciated. So let me put this. Y'all, if y'all knew how many steps it takes, I'm sure you can imagine, because I'm pretty much telling you them as we were going along. Here we go. Okay. Redirect. Done. Okay, guys, have a awesome lunch. I will see you guys at 1:00, and we will get this rest of this show going. Sarah better come with it. Sarah better eat her peanut butter and jelly and close her eyes for a minute and decide to tell the truth once and for all about what happened. I mean, at the end of the day, sometimes you just have to realize I messed up and I got to pay for what I did. That would be the mature thing to do. Okay. We can't depend on that, but hopefully she's going to eat her lunch, sit back and reflect on the right thing to do, because there is never a right time to do the wrong thing. That's what I tell my daughter all the time. There's never a right time to do the wrong thing. It's never going to be appropriate. I don't care how you fit it in. There's never a right time to do the wrong thing. Okay. So hopefully she will do the right thing and tell what actually happened and let the chips fall where they may. If you're going to be about that life, handle the business. You know what I'm saying? Anyway, guys, I'm going to let y'all go. I will see you guys at 1:00. Enjoy your lunch, and I'll see you guys in an hour. Okay. Bye, guys. Love you. Mean it.